Hello and welcome to the American Compass podcast. My name is Oren. I'm the chief economist at American Compass. And today we are talking labor enforcement with a Biden administration official, Seema Nanda, who was the Solicitor of Labor pretty much for the entire Biden administration and has obviously a lot of experience and also, I think, a lot of really valuable perspective on what the Labor Department actually does, what our labor laws are, what it takes to actually enforce them, where the employer community is on all this. It's somewhat puzzling, I would argue, that employers don't recognize consistent and robust enforcement of labor law as a benefit to those who, in fact, want to follow the law. That's a bit suspicious. And then, of course, conversely, on the other side, we have an awful lot of worker rights activists, labor unions, and so forth that don't see enforcement of our immigration laws as important to maintaining high labor standards, robust enforcement, and good jobs. That's a little bit suspicious too. So it's a really interesting conversation, I think, about, getting beyond the kind of, well, what should our laws be, to the actual question of what does it take to enforce them? What are the priorities? What are the trade-offs? Who likes various elements of this? Who dislikes various elements of this? And I think ultimately, therefore, a lot of implications for where a Trump administration can and should go and focus, and more broadly for conservatism moving forward, what it looks like to actually have a consistent and coherent agenda that is committed to law and order, that is committed to workers' interests, and is committed to doing it in a way that is respectful and supportive of good employers, but frankly doesn't have a lot of patience for bad ones. So really appreciated her coming on the podcast. I think it's a really interesting discussion. The first half is mostly on typical labor laws, second half on immigration. Hope you will enjoy it as well. Of course, got to tell you about what else is going on at Commonplace. Have a bunch of good stuff coming this week. If you didn't see it, be sure to read the review that Evie Solheim wrote for Leah Sargent's new book, Dignity of Dependence. Really interesting discussion of care in particular, which is obviously a very important theme on the family policy front. Doing some really interesting stuff on immigration, doing some stuff on rare earths. So be sure to check all of that out. Of course, Understanding America on Fridays. But here is Seema Nanda. And Seema Nanda, welcome to the podcast.
Thanks so much for having me, Oren.
Thank you for joining us. Really looking forward to this conversation about, well, frankly, all things Department of Labor, which I think, myself included, people don't tend to actually know all that much about what it does. We know we have a lot of laws, but what it means to actually enforce them, who's on what side of what the priorities should be, what we can do better, I think are all issues that especially folks on the right of center who have become a lot more interested in the topics are still trying to kind of wrap their head around. And so I thought it'd be really interesting to get your perspective on that based on your experience, and wanted to start with just the very basics. What was your job at the Department of Labor, and what does that mean you're actually doing every day?
Sure. So I served as the Solicitor of Labor in the Biden administration for almost all of the administration. And basically, the Solicitor of Labor is the DOL's top lawyer. So we're providing legal advice. We do all the things that a general counsel does at any big organization, including a cabinet agency. But the solicitor's office is a unique role because we're also actually enforcing the labor laws. So when employers don't comply with the laws, we are the ones going to court. So it's an office that, when I was there, I think it's gotten smaller, had about 650 staff, about 500 attorneys, and those attorneys are actually going to court and enforcing the laws. All of the agencies that you have probably heard about, like like OSHA and the Wage and Hour Division, we're essentially their lawyers. And we also do a lot of work on the rules, regulations that protect workers.
And so what are the top laws? I mean, as you said, people have heard of OSHA, people know about Fair Labor Standards Act, et cetera. What kind of broadly or in terms of specific issues, violations are the biggest share of the caseload or the biggest concern?
Sure. So I think under the Fair Labor Standards Act, by far the biggest area of cases were overtime violations. We had cases, minimum wage cases too, but the minimum wage, as you know, was quite low in this country. But we still had cases, especially around training cases where workers are doing training for a job and they're misclassified as independent contractors and they're not getting paid for that training. But overtime was by far the biggest case types of cases. OSHA violations. Did a lot of work around fall protection, but all sorts of OSHA cases would keep us busy. But other laws enforced by the Department of Labor are the Family and Medical Leave Act, the Davis-Bacon Act, the Service Contract Act. Davis-Bacon and Service Contract are basically prevailing wage type of laws. Davis-Bacon for construction workers on federal contracts, Service Contract Act for service workers on federal contracts, and we had a fair number of laws that protect immigrant workers and U.S. workers, regulations for temporary jobs, migrant and seasonal worker protections, ERISA, which regulates private sector pensions and healthcare. Um, there was a lot of retaliation. There are a lot of retaliation laws that the Department of Labor enforces as well. Black lung. I could go on.
Yeah.
I think there's over 150 if you
And
actually count all the regulations.
so, I think what's often missing in people's sort of mental images, we have the law, and the idea is, well, if somebody breaks the law, then there's some penalty. But obviously the intervening steps are there needs to be some complaint from somebody. Somebody needs to actually say the law has been broken. There needs to be an investigation. There needs to be an adjudication. Eventually you get potentially to a remedy. Um, how is that typically playing out? Is that typically something that DOL is out there proactively investigating, testing, checking? Is that complaints coming from workers? Is that complaints coming from third parties? What brings something to the attention of the legal apparatus, and then how does it get from there to actually being addressed?
So, so it depends on the statute whether there's authority for the Department of Labor to independently investigate something. But let's just take the Fair Labor Standards Act, which is minimum wage and overtime protections. Um, there was a lot of strategic enforcement, meaning that the department can choose its targets based on a lot of data, a lot of information we're getting from workers, from the industry, other things to sort of say, these are high violation industries. We want to open an investigation. The other half of the cases were complaint based, meaning that a worker or any third party, frankly, could bring those cases to the department's attention. OSHA cases are a combination. They can be driven by a fatality at a workplace, someone getting injured, someone getting an amputation, a fall, but they can also be initiated based on a strategic priority that OSHA has. Say, we had a priority in warehousing, we had a priority related to fall protection. So they can be initiated in different ways. Each enforcement agency, has investigators and they will do an investigation. They will say in the wage and hour context, they might talk to employees. They will initiate the investigation with an employer, ask for certain records, look at things, and how fast that happens really depends on the complexity of the investigation. Um, some some things happen really quickly, and I think there was a big priority that we had at the department in trying to get workers relief as quickly as possible if we could, particularly when there's back wages owed. Over 90% of wage and hour cases would settle, meaning that the workers would have some resolution before it actually went to our shop, the solicitor's office. So the vast majority of cases, and this is true at the NLRB too, are actually cases that are resolved before things get to that.
And how would you say we're doing as as a country, is there, in general, violations getting worse, violations getting better, enforcement solid and robust, enforcement patchy and unreliable? What's your assessment of that?
I think we're really in a crisis point in our country with enforcement, and I think it's related a lot to the budgets. I mean, the budget has basically, a lot of these agencies have been flat funded for uh, 10, 15, 20 years. I mean, essentially flat funded. There's sometimes little pockets of money that come in that you kind of do a patchwork on, but the mission has grown of these agencies. I think the wage and hour division is protecting three times the number of workers that it did, in the early years of its existence, or even 20 years ago. Some of these laws didn't even exist. So we have a workforce that keeps growing, and what flat funding means for these agencies is that you have less people because the cost goes up. The cost of having a federal worker goes up every year. Rent cost goes up every year. Everything goes up, and yet you have flat funding. So it basically means the agencies are getting smaller and smaller. So I think there's a crisis level of funding for sure, and I think in terms of how we're doing, work has gotten more complex. I think we've seen a lot of what we call fissuring in the workplace, meaning that, you used to have, say, a hotel, right? And you had people who worked for the hotel. They worked in the dining room and they were, working for the hotel, and they did janitorial work and they worked for the hotel. And now what we see is, there's a lot of really complex employment relationships. So when we go to investigate a case, you really need to try to figure out, like, what is happening at the corporate level, who is the employer. Just a lot more complexity in those investigations. We also see a lot of risk that used to really be borne by employers and corporations really being pushed onto workers. So, an example of that is independent contractors, employers saying that workers are independent contractors when they really share more characteristics of employees. And that means that the vast majority of all the laws that I'm talking about don't apply to them at all. And those can be, very complex and time consuming investigations as well.
Yeah, that's a really important point that I think gets lost a lot in these sort of classification debates. A lot of the focus on the question about independent contractors, gig workers, focuses on the just sort of the direct private employer-employee relationship. Are they providing benefits and so forth? But for the most part, our structure of both employment and labor law assumes that you have an employee-employer relationship. And so every time you classify somebody as an independent contractor, you essentially drop a lot of obligations to that person. You make enforcement of any of those laws almost impossible. My sense is there's also a problem where laws apply differently in a lot of cases to large employers. And so if you have a fissured situation where the people are technically the employees of a small fly-by-night outsourced firm, they're likely to have somewhat less protection in that respect as well. Um, does does DOL focus on challenging that? I mean, it's ultimately a DOL rule that's kind of defining how classification would work, right?
It is, well, it is there is a DOL rule defining how classification works, but it is also determined by, we have years of circuit court case law in this area, but we focused on it quite a bit. We did a rule at the Department of Labor on independent contractor classification. The Trump administration, the first Trump administration, had done a rule that made it easier to classify workers as independent contractors. That rule was struck down by a court in New York, and we had done a rule rescinding the Trump administration's rule that was struck down. And our strike down was challenged, and it's a whole complicated history. But in the end, right now, the Trump administration has again is no longer applying the more protective rule that we did. But I think to your larger point, it is really important because none of these laws will apply to independent contractors, which is not to say that there are not true independent contractors in our economy and that they play an important role. They certainly do. But what you see is more employers really trying to skirt the rules and say, well, actually, these people are independent contractors, so I don't need to comply with all of these provisions that would really protect them as employees, and they don't have organizing rights under the National Labor Relations Act, which is not enforced by the Department of Labor, but it's a very, very
Yeah.
similar test for independent contractor as well. So,
What's the substance of that dispute? If you were kind of characterizing the key differences between the Biden rule and the Trump rules, or what is everybody fighting about? What do you see as the right way to try to draw and enforce that line?
I think what people are fighting about is there's a multi-factor test that courts have come up with, but really the touchstone that we were saying applies, and I think that the Trump administration was saying applies as well, was is the worker really in business for themselves? And that means, do they really have the opportunity to use their judgment and make more money by doing different things, not just working more hours? And what the Trump administration rule did was to say, well, let's make it a little bit easier to let's make this test a little simpler in a way that's going to make it a lot easier to characterize people as independent contractors. And won't that be easier for businesses, to comply with is basically the substance of it. We saw a lot of cases in nursing homes, right, where companies would characterize workers, even workers that had non-compete agreements. We had a big case that we litigated. The workers actually could not work for competitors, and yet they were characterized as independent contractors. And the only thing that they could do to determine, how much more money they make is work more hours, right? So these types of cases could have really detrimental effects on an industry, on low wage workforces. But unfortunately, the rule that we had done now is no longer in effect. They did essentially just said we're no longer going to enforce it.
Hmm.
But it was more protective of workers to as you go through that test.
Yeah. The point about what employers want and are arguing for, I find fascinating. Let me sort of present a wildly naive and obviously untrue uh, thought about the world, but I'm curious why it's untrue. Because, the funny thing about all this employment law is that the problem with, well, let me put it this way. If everybody complied with the law and were held to the same standard and same floor, it wouldn't necessarily be a competitive problem for anybody. This would be what they were all dealing with. When you have some companies and employers try to skirt it, try to reclassify as independent contractors, just not comply with various elements and hope they don't face enforcement, that's obviously a huge problem for the workers that are facing that. That's also a huge problem for the competitors who are trying to provide good jobs and follow the law. And so, in my naive worldview, I would expect an upstanding corporate citizen or an entire upstanding organization of, let's say, a roundtable of businesses, hypothetically, to be really enthusiastic about aggressive and robust enforcement that would be good for those companies that are following the law. And yet that seems to never be the posture of the employer community. Um, how would you describe that dynamic and why does it play out the way that it does?
Yeah, I think it's a great point, Oren. I mean, I think you're absolutely right. Um, Employers that are not following the rules of the road, particularly on such big systemic things as are you characterizing your workers as employees, undercut the market for employers that are following the rules, upstanding employers that are doing things the right way. And I I was, sometimes surprised that we we didn't have more support. I want to say though, it's not that it never happened. We would sometimes have employers come to us and say, "Hey, this is not a competitive practice that my competitor is engaged in." So I would say it's not that it never happened, but it's not what we were generally hearing from the business community. There weren't, we didn't get a lot of support for our rules, a lot of support for our enforcement, unfortunately.
Hmm. And it, thinking about it, it certainly makes sense that you'd have an individual employer face a situation where, hey, my competitor over here is doing X. That's a problem for me. But at more the, industry association level or the kind of corporate community level is, I guess if I'm trying to look at it from their perspective, it would be, well, all things equal, we'd prefer a lower floor to a higher floor. All things equal, dealing with investigations, dealing with enforcement is inconvenient and costly. Um, and so to some extent, kind of the, the wild, a wild west is preferable to a high floor, robust enforcement environment. To the extent that that does seem to be their view, it seems to me that somewhat pushes things back onto the government to find a way to do a better job. I mean, it suggests that enforcement, investigation, so forth, are often costly and inconvenient, even to businesses that are doing the right things and want to follow the law. Do you think they perceive that and there's some truth to that? They perceive that, but it's not the case. What is the upstanding employer's experience that might still leave them frustrated with the DOL?
Well, I mean, we certainly tried to focus our investigations and our work on employers that were most likely to have violations of the law. Um, I think like any regulated party, most employers don't want to be, on the other side of an investigation. But think we certainly tried to focus our work on where we're likely to encounter violations of the law or where there were violations. I mean, certainly if you think about, in the OSHA context, we were often doing cases where someone had already been injured or someone is calling about an injury on the job. The Over half of the wage and hour investigations is because workers are complaining about some sort of workplace issue. I think one thing that I certainly tried to focus on and in the enforcement work is we don't have enough resources to really do enforcement. And I would always tell employers when I would, go out and speak to associations that we weren't going to enforce our way into compliance with our nation's labor and employment laws. But which is why I thought it was really important to go out and talk about what we were focused on. But compliance, that enforcement is a key part to deterrence. It's a key part to leveling the playing field. And so I always tried to think about enforcement, as did I think my counterparts, as being really strategic. Like, where can you be bringing cases that is going to have an effect in this industry, an effect on this practice that is harming other employers and really harming, a broad swath of workers that's undermining labor markets in a particular area. And I think being as strategic as possible is really important.
Yeah. Okay, so I want to flip it around to the other side then. There's what seems like the naive irrationality of the employer community. Uh, I think when you start talking about another huge area of labor enforcement, which is immigration law, you find a very different set of challenges. And so if I were to sort of, again, present the wildly naive view of how the world might look, you would expect the same set of folks who tend to be very focused on unscrupulous employers wanting to see robust enforcement against them, labor unions that are committed to high wages and high scrutiny of employer conduct, to want to see really aggressive and robust enforcement of our nation's immigration laws. Um, and yet that also seems to be something that is not the position that they tend to take. Um, I guess as a starting point, what is DOL's role in enforcement of immigration law in the employment context, and and how does that then kind of show up in the priorities that you have to be balancing?
So, the Department of Labor's protections applied to all workers, regardless of immigration status, and that goes, if you that's sort of a general principle of all of our labor and employment laws are protecting everybody, whether all relief is available. Front pay, back pay is sometimes another question, but they protect everybody. So, in terms of the Department of Labor's role in enforcing immigration laws, I don't think the Department of Labor has a role in enforcing immigration laws. That's enforced by folks at the Department of Homeland Security. I think that your larger point about this tension, I think there is a significant amount of tension. And in my mind, it really comes down to this issue of retaliation. So retaliation was what one of my focuses when I was at the Department of Labor, I should say, combating retaliation, because it really permeates all low wage work. So when we talk about, low wage markets, really exploitive employers, when we talk about the fissuring of the workplace, and you have the brand name company, and then you go to the staffing agency, and then you go down two levels to their staffing agency, to where you get to the really most kind of exploitive um, underground work. That's kind of what I'm talking about. And I think what we see, and even just any worker, this fear of retaliation amongst workers, of it could be workers on a visa that's attached to their employer. It could be a worker that comes from a mixed status immigration family, or it could be a worker that doesn't have work authorization. Maybe they're in this country lawfully, maybe they're not. But when you're talking about that group of really vulnerable workers, I think what permeates their job and what permeates this power dynamic in the workplace is that fear of retaliation, that fear of being fired, being blacklisted. We had cases where, particularly in the temporary worker program, where workers were who complained about job conditions were blacklisted, so they could never get a job in this area, in their livelihood. Right? It's not even, sometimes it was the town, but sometimes it was even broader than that. We saw cases that were just straight up, um, worker complained. We had a case where a worker was injured on the job and actually, had to have a surgery because of their injury. They reported it to OSHA, and the employer arranged for them to be picked up by ICE, right? Despite always having knowledge of whatever status this worker had. The employer decides at that point, I need to call ICE. This is a fairly regular fact pattern that we saw. I think what's even bigger are all the cases that we didn't, right? What just sort of permeates what is happening at these workplaces. So I think when we're talking about immigration enforcement, it's a really complicated question, because I think at its core, employers sort of having this power in the workplace over workers just creates this power dynamic that's really difficult. And one of the things that we tried to focus on is creating conditions where workers could feel like they could come forward and assert their rights, regardless of status, because that does help all workers in the workplace, right? It helps level that playing field. It's not helpful when you are creating sort of different classes of workers in a workplace. And that ability to enforce the law in a workplace is going to help overall the workplace. So I think that is a lot of the tension that you're identifying. It's this it's just something that undergirds the workplace. And so even if you have an enforcement action that on the immigration side that appears separate, it's not going to really appear separate to those workers who are subject to it. It's going to appear like the government just, came there because they asserted their workplace rights, which is frankly a lot of what we see playing out right now in this administration.
Right. I mean, it's an interesting point that the sort of when you have multiple classes of workers, if you have workers of different status, I think, I think as you put it, sort of having a set of workers that are sort of at a lower status with less power at greater risk sort of undermines it creates an unlevel playing field. It undermines the ability to enforce the laws generally, in a sense. I guess the question then is it feasible to address that problem by, thinking that you would take workers without lawful status and essentially elevate them up to the same level? Like, it seems to me inherently the case that if you have a large workforce that does not have legal status, that cannot be legally employed, you are inherently going to have that set of problems. And that is therefore a very strong argument for enforcing the law against employing people in that undocumented status very aggressively, that actually ensuring you don't have that class of workers is really important to the ability to support the rights of legal workers. Um, is that fair, or do you see other ways around that?
So I think when we're talking about it's not a view I share. And the reason is this. I mean, I think if you think about we've had this law since 1986, right? Where employers are responsible for an I-9 process and employment verification. And has it really worked? I think is a question. I mean, the whole idea of the law in 1986 was this is going to deter migrant workers from coming unlawfully to this country for job opportunities. Um, so just query whether this has been a particularly successful strategy. And I think it's complicated. Okay, well, if it hasn't, what do we replace it with? But I will sort of offer that as a nation, our sort of giving what we've empowered employers to do in sort of being these, mini ICE agents and being sort of responsible for scrutinizing documents is not sort of a normal thing that happens in other countries. Like most industrialized countries have some sort of system about related to uh, verifying that you're lawfully able to work, but we're quite heavy in giving employers this particular role, right? So,
Well, actually, I'm actually curious about that. Just to pause that. As what do other countries do? What is the sort of what would you see as the better model for that verification?
I'm in the process of trying to figure that out, Oren. So I don't exactly know, but I think other countries have a little bit more of a like whatever that system is. It's a little bit more if the employer is involved, they're a little bit more of a pass through, right? Of a pass
Yeah,
through on some sort of system that
it's like
then
an e-verify kind of model.
yeah, but e-verify is a very unusual system because it's a system where if there is the way verify works is after the I-9 process, if an employer is enrolled in e-verify or if it's required by their state or in their industry, they essentially take that worker's information and put it in the e-verify system. And if they get what's called a temporary
Yeah.
non-confirmation, something that indicates there's a problem, that information goes to back to the employer, right? And then they're supposed to give it to the worker. I mean, what other system do you have where you can literally not have a job, lose your job, and all of that information isn't even coming to that worker? It's all going through the employer. So E-Verify really continues that level of like giving employers a lot of control in that process, and some real due process issues about how information is really going to that worker.
Hmm.
Um, I used to run the office that does employment discrimination based on I-9 and E-Verify, and we used to see a lot of cases where employers would just go, I don't want to have these problems. They'd run everybody through E-Verify, which is not a perfect system. Uh, Before, they'd run them through as soon as they got enough information, well before an employment offer, and they'd never tell them that they actually, had some sort of issue. And this was an office that did only protect people who were work authorized because it was the point of the office, but they would never know.
Yeah.
So I think there's a lot of issues. I don't know what the perfect system is, but I do think that giving employers this sort of heavy role in immigration enforcement. I mean, if we're talking about um, power dynamics in the workplace, you're just sort of creating one that is going to undermine labor enforcement. So I don't.
Well, well, so
Yeah.
yeah, I'm sorry, I had derailed a little bit what you had been saying with my question about
Sorry.
sort of how other countries do it. But I think the direction we were headed was okay, we have the 1986 law. Obviously, it is far from perfect. Um, but to the extent that I think we agree that having a sort of entire class of workers without legal status and therefore at an enormous disadvantage in all these ways in the workforce, less power, difficult to do enforcement. Insofar as that is a real problem for all workers, harms good faith employers, harms legal workers, what is the path forward on that then?
So so first first I would submit, operating under leaving in place the system we have right now, like assuming we're still going to have a I-9 E-Verify system and ICE and all of those things.
Well,
You know,
feel free to divert from that. Whatever a
well,
better
let me
system
just
would be
take
is
the
fine.
premise that we have the system we have for a
Hmm.
second, and then I can go to a premise where we don't. But if we do have this system, one thing I'll just say in every immigration conversation that we have, and in the 2013 bill, right? Let's just say the last time we had a real plan for comprehensive immigration reform, labor enforcement and the true funding of labor enforcement has not been on the table, right? And in the big beautiful bill, ICE was just given, I think, something like $75 billion or over 4 years. We're talking about um, enforcement agencies that have these tiny budgets. I mean, when I was the Solicitor of Labor, our base budget was 135, $140 million. And that's to enforce, all of our federal nations, almost all of our federal nations' labor laws. We don't do the NLRA stuff, but and so this is really out of whack. And to think that you can um, create a level playing field and fix these things without fixing labor enforcement, I think is really missing a big part of the equation. And I'm not saying it's the only part of the equation, but I think it's a big part of the equation. And we're maybe a long way off from actually talking about some sort of path to take the workers who are here, the maybe it's 10 million workers who are here without work authorization, and figuring out, is there a path for some of them? But I think if we're really talking about stabilizing labor markets, that has to be a big part of the equation. Um, of course, there's the humanitarian reasons and all of the things, but I think if you're really talking about labor enforcement and stabilizing labor markets, that has to be a big part of the equation.
Yeah. And so moving away from to your point that the I-9 system and so forth is highly imperfect. Of course, the thing about the 1986 law was it was a response to the prior wave of illegal immigration, and it was supposed to be part of an agreement that there was going to be a large amnesty, and this was then going to fix the problem going forward, um, stipulating that it certainly did not. And feel free to disagree, but I would stipulate that certainly anything that's going to look like comprehensive immigration reform or address other than through sort of deportation, those are here illegally now, is going to have a better answer than the 1986 model going forward. What would that look like? Especially, I think it's interesting to think of like from the perspective of a solicitor of labor for whom having firm immigration enforcement and maintaining a sort of enforceable labor market is incredibly important. Um, what would you want that system to look like? How do you ensure that people in the country working are authorized to do so?
Um, so so I think of thinking about some broader solutions. I think folks have immediately gone to worksite enforcement as the answer, and maybe some better form is part of the answer, right? But I think one of the things that we haven't fully explored are really thinking about lawful pathways and lawful pathways that actually are more responsive to labor markets, right? Right now, these kind of, we have programs that are sort of legacy programs, and people try to fit their what they perceive to be their labor needs into programs that weren't really quite meant for that. And so we just keep band-aiding a system that is, fundamentally outdated, right? If we think about our immigration laws, I mean, we had some reform in 1990, but really the base of the system is going back to the late 60s, 1965, when we had, really a very different economy, a much smaller labor force. But I think if we think holistically about the system and thinking having a responsive market, actually thinking about what jobs we need, what lawful pathways are there,
Yeah,
sort of thinking about the 10 million workers who are here, thinking about country conditions, what makes folks migrate. I mean, I think a holistic plan would help and be more
right.
thoughtful.
But I guess under any such plan, there are still going to be roughly 7.5 billion people in the world who are not authorized to work in America. So anything holistic and with more lawful pathways and more responsive is predicated on having a mechanism that says if you're one of those other 7.5 billion, you are not authorized to work here.
You mean
So
million? 7 million, right?
7.5 billion. In other words, everybody in the world who is not
Oh,
in the
everyone in the
United
world.
States or on one of
Okay.
these
Okay.
pathways, right? Like everything you've just described, there could be classes of workers that this applies to. It's still predicated on the ability to have borders enforce the law. And if you are not authorized to work, then you in fact cannot work. How do you
Right.
do that?
Well, well, I think you can have an employment verification system that just isn't so one burdensome for employers, but also so heavily dependent on them. I don't think workers want employers to be ICE agents, and I frankly don't think employers want to be ICE agents. So I think there could be models that are more pass-through models. I don't know, exactly what they are, but I think there could be models that
Yeah,
are out there. And if you have border enforcement, if you have, better models, one of the things that we see, like some of what I'm talking about when I talk about labor and enforcement and worksite enforcement, at least as exists right now, there's a lot of enforcement to be done. And my take was always, do you have to be at our workplace? Can you go somewhere else where we're not, because we are not everywhere. So
hmm,
why do we have to be at the same place? Because some of this is just, there's going to be inherent tension in this. It just is. um, an area that employers will always try to sort of exploit the vulnerability of the status of their labor, and that's always going to be detrimental to the enforcement of labor laws. So I think finding mechanisms that sort of reduce that inherent coercion that employers could feel like they have over the worker, trying to get the agencies to cooperate as much as possible. And, I spent a long time in government, and we had years where, cooperation was better,
Hmm.
between the agencies. So just doing the best you can, sometimes recognizing there is going to be this inherent tension.
Yeah. Well, that's a great segue to just a final question in this. In the spirit of cooperation, um, obviously a Trump DOL is going to have different perspectives and priorities in many ways than a Biden DOL did. But there are also potentially some areas of overlap, some areas of bipartisan concern and focus. What's one thing you're looking for that you think is plausible and likely that a Trump administration could be doing on labor law, labor enforcement, that you think would advance some of these priorities that you have as well?
So, I will say that, to date, I've been a little disappointed. I think they put out a regulatory agenda with 50 things on their reg agenda over the summer. And if you really look carefully at them, not one of them is really geared towards advancing the safety, well-being of workers in America. There was a proposal to undo something called the home care rule, which is a rule that extended overtime and minimum wage protections that was promulgated in the Obama administration. I mean, some really basic stuff. But one thing I would really hope that they continue to do, robust enforcement in an even-handed way. I mean, uh, really doing the misclassification cases, letting those cases continue. It was disappointing to see them sort of go back to a easier standard, but I think continuing to really prioritize, robust enforcement, because without it, I think, workers are really going to feel it. I don't know exactly what my successors' plans are, but I hope really continuing some of that basic litigation as deterrence. What we tend to see in Republican administrations is everything is voluntary compliance, and I think those programs are really, really important to ensure that the vast majority of employers are doing the right thing. But without that robust enforcement, you don't have, that really deterrence that you need to really be effective at enforcing all of our laws.
Yeah, no, that makes sense. It is a component of law and order, one might even say. Well, we will keep an eye on it as well. Seema Nanda, thank you so much for making the time and coming on the podcast.
Thanks for having me.
And we will be back again soon with another episode of the American Compass podcast.